All right, man. Church Talk, you know what it is, man. Good morning, good afternoon, good evening. Hey, how y'all doing, man? Good morning, good afternoon, good evening to everybody. Hope everything's good. Hope everybody's good. So there's been an update with the UMG and Drake case. We're gonna talk about this. Before we get into that, I gotta get a legendary spill. This is Torture Talk. If you like the content, please consider subscribing. If you're new here, let me work for your subscriptions today. All the beautiful, single, sexy ladies, put one in the chat. All the fellas, y'all know how to find the ones that just don't harass them. I don't sell no merch, but I do have content absolutely free. But if you want to leave a donation, yeah, right there. Link is on the screen, Cash App. No more PayPal. They call me the Hidden Gem. 1,300 subscribers, over 13, 14, 15, 16, 17,000. Almost 18,000. Yes, I am the king of the north. Let me know what kingdom you from, the Night King. You know what I'm saying? So look, we're going to get into this, man. Sorry, I'm a little bit under the weather. You know what I'm saying? But show must go on. You know what I'm saying? So it don't mean like seem like it, but I keep pausing it because I keep sneezing and all that good stuff. So if you see and then you know it's because I was sneezing. You know what I'm saying? All right, so look, man. Let's get to it, man. Let's do it. All right, this comes courtesy of the Ville. Make sure y'all go and support his channel. And yeah, man. Make sure y'all do his Cash App thing. You know what I mean? Hit him up. All right, so let's get it.
What's going on, y'all? It looks like there's been an update in the UMG and Drake lawsuit. It looks like UMG is making sure that everything is straightened out before discovery goes all the way. Now, if you don't know, the discovery between UMG and Drake in this lawsuit was granted by the judge. The judge had confirmed that they're going to do this discovery. Now, a discovery is normal, just protocol. That is something that is normal in the court of law. It's a routine discovery. The discovery is a stage in a lawsuit where both sides exchange information and evidence relevant to the case, like documents, emails, depositions, and more. Drake wanted to see Kendrick's contracts. He had other requests about other information, emails, all this other stuff. And it looks like UMG decided to submit a protective order. That's right, UMG decided to submit a protective order, in particular to the discovery. Now, the reason why this is so important is for this reason alone. Everybody had asked, why does Drake want to see that information? He just wants to use that information in the discovery so that way he could diss Kendrick Lamar again. Well, this protective order will actually prevent all that from happening. You see, a protective order and a discovery go hand in hand. Like I said, a discovery is the stage in a lawsuit where both sides exchange information. Drake wants the contracts. People assumed he wants it.
But the thing is, with Drake, he made people believe that he already knew what Kendrick Lamar was making in push-ups. That was the whole point of the song Push-Ups. You know what I mean? Drop and Give Me 50, basically saying like you had to give $50 million to get out your contract. But you are in a contract still, which I didn't understand why people were saying like, oh, he had to pay $50 million to get out of his contract. Top made him give him 50. And I'm like, well, why does that matter? Now he's making way more money. It's like Drake mind is so, he has an adolescent mind, man. Like he really does, bro. It's so crazy to see how Drake mind is like a child. And he's a grown man. He's older than Kendrick. And he's like, he still has a mind of a child. It's so crazy.
Information so he could diss Kendrick Lamar again with information that he finds out through the court. However, a protective order and how it works with a discovery, if one party is concerned that sensitive information disclosed during discovery might be misused, an example, Drake leaking it to the public, used by competitors or might cause harm, they can ask the court for a protective order. The protective order puts rules in place, like limiting who can see the information and how it can be stored, or preventing it from being used outside the case. So even if Drake were to get information about Kendrick Lamar through UMG submitting a protective order could limit who can see the information, but not only that, how it could be placed and protected as well, meaning that they could say that.
That's exactly what I was saying. How is it that this guy, I said this on a video a while ago, how is it that the judge would allow him to see everybody's contract? Isn't that private? Like how could you ask for that? You asked for people who had nothing to do with the battle. Like what? Like I don't understand this. How are you even asking for that? But there we go.
Even if they grant Drake the discovery, this is to help prevent it from being used outside in this case. So they go hand in hand by enabling the discovery to move forward without risking harm from disclosure. And this is a common thing, actually. Courts often grant them to balance the need for full discovery with privacy or confidentiality concerns. It says it is hereby ordered that any person to this protective order, including without limitation the parties to this action, their representatives, agents, experts, and consultants, all third parties providing discovery in this action, and all other interested persons with actual or constructive notice of this protective order shall adhere to the following terms. Any person subject to the protective order who receives from any other person subject to this protective order any discovery material, an example, and information of any kind produced or disclosed pursuant to and in the course of the discovery in this action that is designated confidential pursuant to the terms of the protective order. Meaning, if you have access to this, you have to keep your mouth shut and not share it or leak it. You shall not disclose such confidential discovery material to anyone else except as expressly permitted hereunder. Two, the person.
They doing this. They doing this very well. This is this. The way they're doing this is unbelievable. This is like they know that he's going. They know that if he shares any of this information, if he does get this stuff, the case is over. They know that, and they know that that's what he's going to do. He's going to leak this stuff. He's going to. Listen, man. Let me explain something to y'all. Y'all think that Kendrick Lamar is smart, and these record labels be knowing these artists. They've been dealing with Drake for years. I'm telling you, they know. They know. And this was probably going to happen. He's gonna get granted access to it, but he's gonna leak it, and it's gonna be all over for him. I'm telling you.
Producing any discovery material may designate confidential only such portion of such material, the public disclosure of which is either restricted by law or would cause harm to the business, commercial, financial, or personal interests of the producing person and or a third party to whom duty of confidentiality is owed, and that consists of previously non-disclosed financial information, including without limitation profitability, reports of estimate percentage fees, design fees, royalty rates, minimum guarantee payments, sell reports, and sell margins. Basically the numbers, the sales, contracts, all that. You can't share that. You can't share that to the public at all. So even if Drake has access to the numbers, it's not like he could go out there and share them. And if he does, he might face legal repercussions in doing so. Previously non-disclosed material relating to ownership or control of any non-public company, previously non-disclosed business plans, product development information or marketing plans, any information of a personal or intimate nature regarding any individual, which in this case could be Kendrick Lamar, or any other category of information hereinafter given confidential status by the court. Now, this third paragraph is interesting only because they talk about the deposition. They talk about the deposition and how that could be protected under the protective order.
So basically, what it is they making sure that if Drake does go out his way to get all this information, they give them this information. If Drake shares this with anybody, puts it out on a record, anything, if he even alludes to it, they're gonna sue him. They're gonna come after him. You know what I'm saying? So I think that I'll be honest with y'all. Drake dug himself a big hole, man. He dug himself a hole. I just don't see him making out of this one. They're gonna probably settle before they even go. I'm telling you, because his lawyers ain't say nothing yet. After that, the update, they ain't say nothing yet. And then with this, yeah, it's gonna get crazy.
As confidential information. Depositions are handled a little bit differently in a protective order, and I think them pointing this out could be the reason why Kendrick is also doing the deposition at his concerts. I'm not sure if he's aware that he might actually do a deposition, but from what it looks like this protective order could protect any confidential information that's shared in a deposition. It says here, bottom line, depositions can absolutely be protected, but they usually follow their own procedure. They're not automatically public, nor are they automatically protected forever. Someone has to designate them properly. During the deposition, a party or their lawyer can designate certain testimony as confidential on the record, or more commonly, the transcript is treated as confidential in its entirely temporarily. For an example, it could remain confidential for 30 days, giving parties time to review and decide what parties, if any, to mark confidential. After that review period, only the designated parts remain protected. So they'll hold the whole deposition back for whatever time they can, just until they could give it back to the public and redact anything else that they want to keep confidential. But I'm not sure if that's the real reason why Kendrick was doing this deposition scene at his concert on tour. I don't know if he knows he's going to do a deposition, but I just think it's funny how he's doing this cutscene of a deposition on tour. Either way it goes, it looks like the deposition could be protected under this protective order after they exchange discoveries. And 4 and 5 explain that. 5 is also explaining that how a discovery material previously produced by the producing person without limitation could be designated confidential. Then the producing person may so designate by so apprising all prior recipients of the discovery material in writing, and thereafter such designated portions of the discovery material will be deemed to be as treated as confidential under the terms of the protective order. So 4 and 5 basically break down that if there's stuff that needs to be taken out or remain confidential, the protective order will protect that. 6 says nothing contained in this order will.
Yeah, so if he goes around sharing this stuff, it's gonna be bad for him. I'm gonna tell you right now. They're putting this in such a putting Drake in such a position where he can't really do anything about this. And I want to see how his lawyers get around this.
Be constructed as a waiver by party of person of its right to object to any discovery request, a waiver of any privilege or portion, or a ruling regarding the admissibility at trial or any document, testimony, or other evidence. Whether producing a person has designated discovery material confidential, other persons subject to this protective order may only disclose such discovery material or information contained therein too. The parties to this action, their insurers, a counsel to their insurers. Counsel retained specifically for the action, including any paralegal, clerical, and other assistant employed by such counsel and assigned to this matter. Outside vendors or service providers, such as copy service providers and document management consultants, graphic production services, or any other litigation support services hired by counsel and assigned to this matter, including computer service personnel performing duties relating to computerized litigation system, provided such person has first executed a non-disclosure agreement, also known as an NDA, in the form attached hetero. Any mediator or arbitrator engaged in the parties in this matter or appointed by the court, provided such person has first executed an NDA in the form attached hereto, as to any document, its author, addressee, and any other person indicated on the face of the document as having received a copy. Any witness who, in the good faith belief of counsel for a party, may be called to testify at trial or deposition in this action, provided such person has first executed a NDA in the form attached hereto. Any person retained by the party to serve as an expert witness or otherwise provide specialized advice to counsel in connection with this action, provide such person as first executed on NDA in the form attached hereto. Stenographers engaged to transcribe deposition conduct in action and the court, including an appellate court and the court reporters and support personnel for the same. All of this to basically say that anybody that's partaking in this case dealing with the material inside the protective order must sign an NDA so that way they don't go and expose the information that they were exposed to.
I'm telling y'all, they doing this because they know that he is going to leak this. And once he does, it's over for him. And they're going to sue him. I'm telling you. They doing this. They're making you sign an NDA saying that you can't show this to nobody. But we could show you, but you can't show it to nobody. But at the same time, he ain't even talk about it. You could see it, but you can't talk about it. And if they allow this, like if they allow, yeah, it's over. It's over.
That is deemed confidential. Only certain people are typically required to sign NDAs before accessing confidential materials. Outside vendors or service providers, copy services, IT, litigation support, graphic designers, basically making sure that nobody goes and blabs to anybody about the information that they saw in this case. If an attorney brings somebody in, like a technical expert or a financial consultant, they usually must sign the NDA before viewing confidential material. This is just going all over that. Any party who's subject to a designation of confidentiality may at any time prior to the trial of this action serve upon counsel for the designating person a written notice stating with particularity the grounds of the objection. If the parties cannot reach agreement promptly, counsel for all parties shall address their dispute to the court in accordance with the Rule 6 of this court's individual rules and practices in civil cases. Any party who requests additional limits to disclosure, such as attorney's eyes only in extraordinary circumstances, may at any time prior to the trial of this action serve upon counsel for receiving party a written notice stating with particularity the grounds for the request. If the parties cannot reach agreement promptly, counsel for all parties shall address their dispute to the court in accordance with Rule 6 of the court's individual rules and practices in civil cases. Notwithstanding, the foregoing parties agree that any party may designate as attorney's eyes only and previously non-disclosed contracts, agreement, contractual terms, clauses, or provisions, and any document containing excerpts of substantive discussions about the same, the disclosure of which would be highly likely to cause significant harm to the business or competitive position of the producing party. The parties further agree that the defendant may designate as attorney's eyes only any document identifying confidential or proprietary business information regarding defendant relationships with other recording artists or non-parties to this litigation, including but not limited to confidential financial or payment information, revenue reports, royalty rates, licensing rates, and any other commercially sensitive documents. This disclosure, the disclosure of which would be highly likely to cause significant harm to defendant's business or competitive position. The parties further agree that plaintiff may designate as attorney's eyes only any documents identifying confidential or proprietary business information regarding plaintiff's business relationship with non-parties to this litigation, disclosure of which would be highly likely to cause significant harm to the plaintiff's business or competitive position. Any materials designated attorney's eyes only under the paragraph 10 may only be shown to the people in paragraph 7. This part is very interesting.
Yeah, this is crazy. Now, basically what they're saying is all of this is only for your attorneys to see. Unless you sign something or you do something where you get to see it or the attorneys agree to it. All the attorneys have to agree to it. But basically what they're saying is you might not even be able to see this. Only your attorneys could see this. It's for their eyes only. It's crazy.
For the reason why is the attorney eyes only. Now, the bottom line for attorney eyes only, the materials are very restricted to protect business critical information. There's a process to request it, but some categories are already agreed upon as qualifying. Parties themselves, like plaintiffs or defendant, usually can't see attorney eyes only materials. Only their lawyers and the experts can. So Drake himself, he can't see the information. If certain documents are designated for attorney's eyes only, Drake himself likely cannot even see them even if he wanted to. AEO, or attorney eyes only, designation is specifically meant to exclude the parties themselves from viewing extremely sensitive information, even their own lawyer's client. The idea is to prevent business or competitive harm if that information were to be shared with someone who could use it, even unintentionally, to their advantage. In this case, with Drake and UMG, Drake's lawyers can review and use the attorney eyes only material to defend him, but Drake personally can't see it. Let's say a music label produces confidential royalty rates from another artist's contract, and UMG labels them attorney eyes only. Even though that info may relate to industry practices that Drake cares about, he can't see it. Only his legal team can. If they're involving highly sensitive information, they're making sure they set everything straight before giving it to Drake's team, just to make sure that only his legal team could look at it, and to be very sure that Drake doesn't leak this information out to the public, bro. A lot of people thought that that's what Drake wanted to do. Drake wanted to get Kendrick's contract. He wanted to leak it. He wanted to share whatever it is that he saw. But it looks like they're doing all the proper procedures to make sure that that doesn't happen. A party may be requested to.
But my thing is, like, even if he did do that, what is it gonna do? Absolutely nothing.
Produce discovery material that is subject to contractual or other obligations of confidentiality owed to a third party. Within 5 business days of receiving the request, the receiving party subject to such obligations shall inform the third party of the request, and further that the third party may seek a protective order or other relief from this court. If neither the third party nor the receiving party seek a protective order or other relief from the court within 21 days of that notice, the receiving party shall produce the information responsive to the discovery request, but may affix the appropriate confidentiality designation. So 12 and 13 is basically letting you know that even though that this might be a protective order, and even though it keeps information confidential, this doesn't prevent anybody from having a fair trial, a fair case, a fair day in court, however you want to put it. 13 is saying if anybody decides to get involved, any law or government agency, which is interesting, decides to get involved in this case, they would have to notify the court, I'm assuming is what they're saying here. In accordance with Section 10 of this court's individual rules and practices in civil cases, the party filing documents under seal must first file the court a letter motion explaining the basis of the sealing such documents. The party should be aware that the court will unseal documents if it's unable to make a specific on the record findings, demonstrating that the closure is essential to preserve higher values and narrowly tailored to serve that interest. There is no presumption that confidential discovery material will be filed with the court under seal. The parties will use their best efforts to minimize such sealing. The court also retains unfettered discretion whether to afford confidential treatment to any discovery material designated as confidential and submitted to the court in connection with any motion, application, or proceeding that may result in an order and/or decision by the court. All persons and hereby place on notice that the court is unlikely to seal or otherwise afford confidential treatment to any discovery material introduced in evidence at trial. Even such material was previously sealed or designated confidential. This right here is letting you know that at the end of the day, the court is what deems what is confidential and what is not. That's what 15 is basically telling you right here. Filing confidential discovery material with this court or filing portions of any pleading motions or the papers that disclose such confidential discovery material, the party shall publicly file a redacted copy of the confidential.
Yeah, that's crazy.
Court submission via electronic case filing system. The party shall simultaneously file under seal via ECF with the appropriate level restriction and unredacted copy of confidential court submission with the proposed redactions highlighted. Each person has access to discovery material that has been designated confidential, shall take all due precautions to prevent the unauthorized or inadvertent disclosure of such material. Number 18, they talk about personal information such as names, numbers, and all that, socials, all that. If a disclosing party makes a claim of an inadvertent disclosure, the receiving party shall within 5 business days return or destroy all copies of the inadvertently disclosed information and provide a certification of counsel that all such information has been returned or destroyed, making sure that the material is not kept, making sure that they do get rid of it if they have to get rid of it, whatever the case may be. Within 5 business days of the certification that such inadvertently disclosed information has been returned or destroyed, the disclosing party shall produce the privilege log with respect to an inadvertently disclosed information. Got to confirm that. Got to make sure that they do not keep information. Got to make sure that they delete it, remove it, burn it, whatever they got to do. The court has to make sure that they haven't kept anything after the fact. The receiving party may move to the court for an order compelling production of the inadvertently disclosed information. The motion shall be filed under the seal and shall not assert as a ground of entering such an order fact circumstances of inadvertent production. The disclosing party retains the burden of establishing the privileged protected nature of the inadvertently disclosed information. Nothing in this order shall limit the right of any party to request an in-camera review of an inadvertently disclosed information. The protective order shall survive the termination of the litigation and will continue to be binding upon all persons to whom confidential discovery material is produced for. Within 30 days of the final deposition of this action, all discovery material designated confidential and all copies thereof shall promptly be returned to the producing person. Alternatively, upon permission of the producing person of all confidential discovery material, all copies thereof shall be destroyed in either event of a 30-day deadline. The recipient must certify that the return or the destruction of confidential discovery material and all copies thereof by submitting a written certification to the producing party that affirms that the recipient has not retained any copies, compilations, summaries, or other forms of reproducing and capturing of any confidential discovery material. Notwithstanding the provision, the attorney specifically retained by the parties for representation in this action may retain an archival copy of all pleadings, motion papers, transcripts, export reports, legal memoranda, correspondence, or attorney work product, even if such materials contain confidential discovery material, and such archival copies that contain the constitute confidential discovery material remain subject to this order. All persons subject to protective order acknowledge that the willful violation of the protective order could subject them to punishment for contempt of court. This court shall retain jurisdiction over all persons subject to the protective order to the extent necessary to enforce any obligations arising hereunder or to impose sanctions for any contempt thereof. Basically, if Drake goes around and violates anything regarding this protective order, he could face legal repercussions and he could see himself go to court because of it. This is big dog business.
That's exactly what I said. That's what I said. They're doing this because I believe that they believe he's going to leak all this, and they trust me. They covering everything. They're covering.
They do believe that they're letting Drake know that you're not going to leak any information that you get from us. Actually, you might not even see any of the legal information that we give you. The only people that have a right to see that information is Drake's lawyers themselves. Attorney eyes only. Either way, this protective order is something that they're going to make sure that they do, so that way Drake doesn't go and leak information, isn't going to go online, isn't going to make a song or a diss track talking about Kendrick Lamar's contract. You're not going to see any of that. Why? Because if he does that, then he breaks the protective order and he has to see a day in court and face legal repercussions for that.
That's true. 100%. Yeah. So they covering everything. And I still ain't see Drake's lawyers rebuttal because I believe that this case ain't gonna go no further. I believe that they put that update in. I believe that now it's kind of like for Drake, the battle has kind of settled down. Really nothing else he can do. I think he's gonna dismiss this case. He's gonna probably try to dismiss it because him going forward, he's gonna go broke. Once they go to trial, it's something different. And I think the trial is supposed to, I don't know if it's supposed to start, but there's something supposed to go on. So, but we'll see, man. We'll see. Thank y'all for joining me. I appreciate y'all. I'll see y'all on the next one, man. Make sure y'all go to Torture Talk After Hours too and go check me out over there. You know what I'm saying? I'll be doing some things over there. All right, see y'all. Peace. Bye.